So in this presentation, I'm going to canter through the provisions of the offtake arrangement covering default by the parties and resulting termination of the PPA. In the ordinary course of commercial activity, people don't sign contracts expecting the other party to default or to default themselves. That's true generally, but especially for PPAs in the markets in which we operate. In our markets, demand for power generally outstrips supply. And that means a buyer of power doesn't want to terminate a contract under which it receives much needed electricity. From the seller's perspective, these markets are normally single buyer systems with just one entity that a seller can sell power to in the country. So if a seller loses its PPA with that off-taker, it's left with a stranded asset, unable to sell its power to anyone else. Happily, these factors incentivize both sides to keep the power project running and the PPA functioning. They would seem to take the pressure off the default and termination sections of the PPA. And speaking generally, power projects in Africa do have a good record of functioning as the parties expect. But these provisions continue to be fundamental to that success for two reasons. One, because thinking seriously about all the things that can go wrong helps all the parties to put in place the measures to stop those things happening in the first place. And two, because the way breaches are dealt with is fundamental to the decision of developers and lenders to develop and lend to a project. So if we go to the next, we've got limited time, and this presentation is not supposed to be an audiobook version of the default chapter. So I'll try to focus on the key points I think the parties to a PPA and other stakeholders should focus on. So I'm going to focus on three things. First, a couple of basic principles that should apply to the default section. Then, what a useful cure regime should look like. And lastly, a couple of pinch points in the context of termination payments. So if we turn to the next slide. Two quick and straightforward principles to highlight that should be reflected in the description of the defaults of the seller and the off-taker. The first is that a party shouldn't be penalised when it fails to perform under the PPA because of the other party's earlier breach. To take the simplest example, if the off-taker doesn't pay for the power the seller generates and the seller ends up in liquidation as a result, the off-taker shouldn't then get a right to terminate the PPA under the seller insolvency event of default. Rather, the seller should have a right to terminate for the off-taker's non-payment. But equally, if the off-taker is paying on time, but the seller has got embroiled in some litigation, say with a contractor or a neighbour, and has to make a substantial payout that leads to it going into liquidation, then the off-taker should be able to terminate the PPA for seller default. So the default provisions of each party should make clear that the relevant act or omission should not be a default where caused by the other party's default. The second principle is simply that the default regime and the so-called non-default event regime, which in particular looks at force majeure, should be kept separate. If there's an earthquake that delays plant construction, so the seller misses the deadline for achieving commercial operations in the PPA, that should not be a default under the PPA. There should be provisions in the relevant events of default section that makes clear that failure to meet contractual obligations caused by force majeure affecting a party are not events of default. There's an important caveat to that, of course, which is that force majeure cannot be an excuse for a failure to pay. That's as true in a loan agreement as it is in a PPA. If you allow that, you can fatally undermine the viability of the project because you create the potential for the off-taker to run arguments relating to matters beyond its control, such as end users not paying their bills on time and causing the off-taker to be out of pocket as a reason for it not to pay. If that becomes a legitimate excuse for non-payment, developers and lenders will simply not invest. This issue has come to the fore in light of the recent drop in electricity demand caused by COVID. I can think of only one jurisdiction where standard PPAs allow FM to apply to non-payment, and there the consequence is that the payment obligation is simply shifted to the government. If we turn to the next slide, let's talk now about what a useful cure regime should look like. Whether it's buyer or seller defaults we're talking about, everyone should want them to be not just minor, even repeated minor lapses, but serious breaches. That means ensuring that if we're talking about insolvency, we mean the late stages of an insolvency process, not just technical inability to pay debts as they fall due. And a general provision about failure to comply with obligations should include a materiality qualifier. But there should also be time to fix the problems, and everyone who can fix the problems should have a chance to do so. For that reason, the lender group, which usually comprises around 70% of the funding of the project, will want to see reasonably long cure periods in the seller events of default. And in addition, they will want direct rights in a direct agreement. If we look at the next slide, they'll want to be informed by the off-taker of any breach by the project company. They'll want to have an extended cure period for the project company to fix things before the off-taker can exercise its termination right. For serious breaches, they'll want the ability to step into the shoes of the seller and fix the problems themselves. And if all else fails, they'll want to find someone else to run the plant and novate the PPA to them. The off-taker may be nervous about the length of cure periods, preventing it ever getting to exercise its remedies for breaches by the project company. And of course, a counterparty breaching a contract is a situation no one wants to find themselves in. But the fallout of a termination is almost certainly worse for all sides in terms of effort and outcome. And as we'll see, when we discuss termination, longer cure periods may have a payoff for the off-taker in terms of termination events. Just one point to note in passing. Why novate the PPA? Why not simply transfer the shares in the project company to new competent shareholders of the existing project company and have the PPA and all other contracts just stay where they are? That will usually be the simpler option, but sometimes there may be some unquantifiable liability sitting in the project company that can't be effectively priced into the purchase price for the shares, and so makes the project company's shares an unappetizing acquisition. Better in that circumstance to be able to effect an asset sale of the project and novate the PPA and other contracts to a new, clean, special purpose company. The novation rights in the direct agreement keep that avenue open. So if we go to the next slide, we can turn now to the termination provisions themselves and some key pinch points between the parties. It's important to remember the basic setup of the termination regime is in two stages. Step one is termination of the PPA, and the question is who has the right to terminate. As you would expect, the party at fault cannot terminate for its own breach. For other matters, such as force majeure, the picture is more mixed, but typically either party can terminate for prolonged force majeure, provided there's no restoration program ongoing. If we go to the next slide, step two is then the separate right to either sell the power project in case of the seller or buy it in the case of the off-taker. This is often set up as a put and call arrangement as shown in this slide. The seller can put the plant to the off-taker or government, and the off-taker can call for the plant to be sold to it by the seller. Chapter 8 of the book describes whether one or both parties gets a right to put or call the plant in each different scenario. The scenarios are essentially seller default, off-taker default, force majeure, including political force majeure, and other events like change in law and expropriation. It also looks at the different elements incorporated in the termination payment, depending on the different scenario. In the little time we have available now, I want to highlight two specific points touched on in this chapter. So if we go to the next slide. First up, the off-taker and government will expect that over time, their liability in case of a termination payment will decrease. The off-taker's payments for the power are paid in the expectation that they're used to pay down the debt. But there's usually nothing in theory to prevent a developer-friendly lender changing the debt repayment schedule, pushing more of the principal repayment towards the end of the repayment period. That means that a larger proportion of the early revenue from the project goes to the developer, thereby boosting the equity return. That in turn would mean that a termination late in the project's life would lead to an unexpectedly large termination payment for the government. To avoid this risk, as we note in the book, the size of the debt portion of the termination payment can be limited by reference to the original repayment schedule for the loans. Where that approach has been proposed, the parties have quickly identified the need for some carefully thought through exceptions. First, where delays in payment of the debt are caused by factors that have prevented the project company from receiving its normal revenue, the repayment schedule should be disapplied. Most obviously, an off-taker non-payment should lead to this outcome, but there are others. A change in law imposed on the project by the government may oblige the project company to increase its capital or operational expenditure and to borrow additional funds to do so. In that case, the schedule would need to be revised to allow for the additional debt. And if it's a renewable plant, susceptible to reduced revenues because of low levels of rainfall, wind, or sunshine, the repayment schedule may need to vary to cater for a low generation year. While the goal of governments seeking to ensure that their debt payment obligations reduce over time is understandable, these various factors can lead to the unintended consequence of lenders not receiving their full termination payment. So if it is to be adopted, it will need to allow for these scenarios. If we turn to the next slide. Lastly, I want to talk about the seller's right to put the plant following a seller default. There's always some talk about how the market is shifting away from lenders insisting upon a right for the seller to put the plant and obtain a termination payment to cover their outstanding debt, where the PPA termination is caused by a seller default. As a general statement, this can lead to unrealistic expectations from off-takers and host governments, which have the effect of hindering the development of much-needed power projects rather than speeding them up. The first thing to say is that there will be a laser-like focus from credit committees of lenders to power projects on these termination provisions, especially where, as I've already said, the loss of the PPA will lead to the project having no other buyer of power and so becoming a stranded asset. As is right for lenders that take low returns in exchange for strong protections, those committees will want to understand how they go about recovering their investment in each termination scenario. That fact should be at the forefront of the minds of governments looking to develop projects that will attract the necessary debt capital to proceed. It's important to be clear about what triggers the payment. There's sometimes a concern that a seller could deliberately breach the PPA with a view to then terminating it in order to receive the termination payment. This is clearly not possible because the PPA does not permit the seller to terminate the PPA for its own breach. It's only after the off-taker has exercised its right to terminate the PPA for seller's breach that the seller gets a right to transfer the plant and be paid for it. It is true that there are cases where some lenders will back a project without a seller having a put right for seller default, but only in very specific circumstances. Timing matters in this discussion. In the period of construction of the plant, the job of meeting PPA requirements is largely transferred as a factual matter to the contractor. The terms of the construction contract may well provide that if the plant is not built to the minimum specification required in the PPA or by the ultimate deadline set out in the PPA, then the project company can reject the plant and obtain a full refund of the purchase price. The lenders will then use that purchase price to repay their debt. So the absence of a termination payment for seller default in the period up to commercial operations date may not be fatal to the project's bankability, provided the terms of the construction contract are suitable. In the operations period, lenders will consider a host of factors. Two that often go together are the type of power plant and the terms of the PPA. Complex thermal plants with many parts that could go wrong are often designed to be dispatchable with minimum annual power delivery obligations. That sort of project has a higher risk of default associated with it, and so a PPA without a termination payment for seller default will probably not get through a lender's credit committee. But if it's a relatively simple construction, like a solar project with a PPA that simply requires the project company to sell all power it generates without any minimum delivery obligation, that may get past the first hurdle. The next factor will be the cost of the power. The tariffs on renewables projects have been falling dramatically in recent years. That creates the risk that a government may look for a way out of an expensive PPA if it can replace it with power from newer, cheaper projects. If it can do so without making a termination payment, that may prove a strong temptation. In that scenario, a lender will ask itself whether there are any seller defaults in the PPA that the off-taker could control and misuse, for example, preventing reissuance of a key license, and what the track record of the off-taker and government is in developing IPPs and honouring their contract. And lastly, they will look at the length of the cure periods available to enable the seller and the lenders to remedy any breaches that do arise. So as we mentioned before, long cure periods and strong direct agreement protections will make a big difference in a lender's calculation of the risk. To summarise, in case of renewable projects selling power on an output-only basis with well-constructed PPAs, providing generous cure periods, in a market with a good track record for honouring PPA obligations, I believe lenders will lend on the basis of a PPA without a seller put right following seller default. And indeed they have. Examples of this include the South African REIPP programme, and in the right setting, the scaling solar offtake arrangements. To suggest that it's the norm without those conditions applying, even though it has happened on occasion in the past, is probably counterproductive. Jurisdictions without a track record may save themselves a lot of effort and time if they focus their energies on running a successful programme, providing the put right for seller default as part of an overall bankable package, demonstrating good performance, and then reaping the benefit in the second and third rounds from falling tariffs as the reduction in the risk premium is factored into the tariff they pay and an improvement in the risk allocation lenders will accept. And that's the end of this section.